Ward, and welcome to my Google Hangout Air webinar. And today we're talking about how to protect your trademark. So let me just do a couple of housekeeping items. Number one, we're having a little bit of a problem with the chat and the Q&A. So here's what I'm going to do. I'm going to stay on to Twitter. I'm actually going to go on to Twitter for about 30 minutes after this call. So from about 10:30 Pacific Standard Time until about 11 a.m., I'm going to be on Twitter and I'll be chatting with you. And if you've got some questions, feel free to go ahead and send them to me. And if by chance I can't get your questions answered there, I will either do a blog post, I'll do a short video, or I'll schedule another Google Hangout Air webinar. Okay, so let's get started. Today, we are going to talk about 6 things that you absolutely must do if you are going to, number one, get that registered, get that trademark registered, and once you get it registered, if you're going to keep it. So let me open up screen share. There we go. Okay, so this is cool. I'll tell you, once you get the hang of this Google Hangout Air webinar stuff, it's great, but it takes a little getting used to. So again, I'm attorney Francine Ward, and you guys can find me anywhere. Most of you've seen me all over the place. I'm on LinkedIn. I've got discussion groups going on. I've got a blog post that I do weekly. I'm here on Google+. I'm on Twitter. I'm on Pinterest. I'm everywhere. You can find me on my website, on YouTube. So I'm easy to be found. I've got a Facebook fan page. So there's no problem. If you're looking for me, believe me, you can find me. So let's get started with what is a trademark. Since this topic today is all about trademarks, what is a trademark? Well, a trademark is a distinctive device which identifies the source of a product or service. And essentially what a trademark is, it's a source identifier. It's the thing that lets you distinguish one business or service from another. So what are some devices that can actually be protected by trademark? Well, words, logos, phrases, designs, packaging, fragrances, sounds, all kinds of things can be protected by trademark. Names in some cases, not always. You can't always protect a name. You can't always protect a phrase. You can't always protect a word. But if they can be protected at all, they're going to be protected by a trademark. So a trademark essentially is really just a brand. It's the thing, again, it's the outward packaging, it's the outward design, it's the word, the outside of the package that distinguishes one brand from another. So a great example, if you like hamburgers, for example, there are several big brands. There's McDonald's, there's Burger King, there's Carl Jr., there's Wendy's. I mean, there are many of them, In-N-Out Burger. If you are a fan of McDonald's, even if you pass the Burger King, you're not going to stop in there because you want McDonald's. If you're a big fan of In-N-Out Burger, you're going to go to In-N-Out Burger and you'll drive right past a Wendy's or a Carl's Jr. because the brand that you've developed a relationship with is in fact In-N-Out Burger. So that's really the power of a brand. That's the power of a trademark. And that's why people are so interested, at least smart business people are so interested in getting that trademark protected because they know once they have it, they can build around it brand loyalty. So some examples of trademarks other than the ones I just gave you are Twitter. And these are all registered trademarks, YouTube, Facebook, McDonald's. And look here, the interesting thing about this is not only, if we're looking at the McDonald's, we look at the golden arches. So the golden arches are registered trademark. I'm loving it, which is a phrase, is a registered trademark. And the word or the name McDonald's is also a registered trademark. So all 3 of those, and then they've got many more. They've got Big Mac. I mean, they've got a ton of them. But just as examples, these are some registered trademarks. Not only is the word Mercedes-Benz or the name Mercedes-Benz a protectable trademark, but so is this logo design. Coca-Cola, not only the words, but the shape of the bottle is protected by packaging. Trade dress, the logo is protected. So is Pepsi and the logo design there. TiVo as well as the logo are also both protectable trademarks. So these are some examples of trademarks, and these are all trademarks that you guys know. You've seen them on a regular basis, you know them. And the reason you know them is because each of these companies has invested a lot of money and a lot of time in making sure that you know them. They've built out their brand in every way possible. And in fact, what's very interesting today is you see all of these brands right now in social media. You know, there was a time when social media just got started when you didn't see a lot of companies stepping in and taking the risk. But today they're all there. Every single one of them. So let's talk about the 6 things that you absolutely must do if you're, number one, going to get a trademark that can be protected, and number two, once you get it, if you can protect it. The first thing, and this, guys, I have to tell you, is the most important step, bar no other. You must absolutely choose wisely. You must select a trademark that, in fact, can be protected. And why is that so important? Well, number one, if you choose a trademark, if you choose, let's say, a word, some device, a word or a slogan or a name that, number one, is not acting like a trademark, then even if you go through the process of paying the money, either doing it yourself or paying a lawyer to file an application for you, I can tell you without question, it's going to be rejected. So all that time and all that money, all that investment is going to go to waste because you did not choose wisely. I have a client recently who came to me and said, Francine, I know that, and this is how they said it to me. They said, I know that Audi is a trademark. I know they already have a brand, but I want to create and actually he was thinking about doing a patent for some device that goes into an automobile, but he wanted to call it something Audi. So I said to him, you know, there's no way you're going to get that. I mean, there's, even if we filed an application, Audi will be at the front door filing office actions like you would not believe. You will never ever get that through the system. He said, but how come? It's not an automobile, it's for a piece that goes in an automobile. And I just couldn't stop laughing. I mean, I just couldn't stop laughing. So here's what I suggest to all my clients who are having difficulty trying to figure out how to select a name. Here's the process that I put them through. Number one, the most important thing in choosing any trademark is distinctive. That is the word we use in the law. It absolutely must rise to the level of being distinctive, something that stands out, something that's unique, something that's different from every other person's brand. So the first thing you want to do, and this is at the very top of the list, we're going to go down the list of things that can be protected. And the items that almost always are protected unless someone else has it. Now, that's the exception. Unless someone else has it, or if it's a scandalous mark or something like that. But if it's considered coined or fanciful, almost without exception, you're going to get it registered unless someone else is using it, or unless it's considered scandalous. So that's at the top of the list. And what's a coined or fanciful mark? It's something that you really just make up. That's the best way to describe it. In layman's terms, it's something that you've made up. So for example, Xerox, Nike, those are examples of made up terms. Who would have ever thought of that? Xerox or Nike. They're made up, and as a result, they're both protected by trademark. The next level that almost always can be protected unless someone else is using it is what we call arbitrary terms. So arbitrary is really cool because really an easy way to think about this is where you put together two words that would not normally go together. So for example, Microsoft. That's a really good example, I think, because who in the world would have ever thought, like however many years ago before Microsoft came onto the scene, who would have thought to put together the words Microsoft for a computer company? Nobody. Nobody. But yet, Microsoft together became a protectable trademark. Another great example is Apple computers. So when I was growing up, if someone used the term apple, rest assured they were talking about a piece of fruit because that's all we ever connected the term apple with. Apple, fruit. But today, if someone says apple, especially anybody who's probably under 50 or under 60, I'd say 50, then if they say Apple, they're definitely talking about Apple computers or some Apple product or service, Apple iTunes, Apple iPad, Apple iPod, something related to Apple computers. Another arbitrary term that was put together that's also protected by trademark is Domino. Domino's Pizza. Now, when I was growing up, if someone ever used the term dominoes, they were thinking about that little game with the little black pieces that fall down. I mean, that's what I grew up thinking about when I heard the term dominoes. But today, if someone uses the term dominoes, I know without question, most of you are going to be thinking about the pizza chain because that's how powerful that brand is. And because they put together two words that would not normally mix, there you go. Now, let's say, for example, you have a trademark name, and let's say you want to, let's say you want to open up a restaurant, and you want to call the restaurant the restaurant. Well, I can tell you that actually, before I go there, let me just step down one more. The next level that almost always can be protected, but it's a little questionable. And these two actually I'm going to put together, suggestive and descriptive. There's a very, very thin line between what's considered suggestive and what's considered descriptive, and descriptive trademarks almost never can be protected. I'm not going to say they never can because there are absolutely exceptions, but they almost never can be protected unless unless they've established some kind of secondary meaning other than just talking about what that thing is. So an example of a suggestive trademark is copper tone tanning oil. So copper tone, it suggests what it's about, that it's something that tans your skin and makes it copper, like the copper tone. But it's very, very suggestive. It's not coming right out saying, this is a tanning oil, the tanning oil. So if they came out with a product called the tanning oil for tanning oil, they would never get that registered. If they came out with a trademark called the restaurant for the restaurant, they would never get it done. I had a client once who wanted to register the seminar company for the seminar company, and I had another one who wanted to register the speaker bureau for the speaker bureau, and of course they could not get it registered because those terms are clearly descriptive. But what I suggest to clients so that they don't fall in this middle area and end up having to receive an office action that they have to respond to, I say it's better when you're coming up with a creative term, a distinctive term, you want to stay up in these two categories. You want to make up something, or you want to come up and put together words that would not normally go together. Let me give you another example. Speaking of arbitrary, one of my own personal trademarks is fear covery, where I put together two words, fear and recovery. So it's fear covery. Two words that would normally go together, but I put them together, and there I've got a registered trademark. So again, I think in coming up with a term, you really want to stay up in the fanciful and arbitrary area. And you absolutely do not want to come up with a term that's generic. And a generic term would be something that actually describes what the thing, that says what the thing is. So for example, bread. You can't register the word bread. You can't for bread. You can't register the word coffee for coffee. You just can't do it. You could register the word coffee for restaurant, or you could register the word coffee for maybe a piece of clothing, but coffee for coffee, there's no way you're going to do it. So the very first thing, and I spent a little bit more time here because this is the most important thing you can do. Choose wisely. Choose your trademark wisely. The next thing is to perform due diligence, and that is to do a search. Clear your mark. That is the second most important thing. After you choose a trademark that in fact can be protected, the next thing you want to do is do a search. Now, there are different kinds of searches. And there are different times when you would actually do a search. So what are some times when you would actually do what we call fact finding, doing clearance? Well, the first thing is when you're starting a business. When you're starting a business, you should absolutely always do a search, especially if there are any trademarks involved, or if you want to have a trademark attached to your business, you want to do that right away. When you're acquiring a business, if you're buying a business or buying assets from someone, you want to do a search. If you're building a brand and you're building a brand around a new logo or a new design or a catchphrase, you want to make sure you get that registered in the very beginning. If you're licensing a trademark, you want to make sure you've done a search. And I'll give you an example of why this is so critical. A client of mine about a year and a half ago came to me with a licensing agreement that they wanted me to negotiate. And so in reviewing the contract, because not only am I a business lawyer, I'm also an IP lawyer, intellectual property. So they brought me the contract, and the first question I had for her was, did you do a search for the trademark to make sure that the trademark was in fact valid, especially because this licensing relationship was about the trademark? Well, she says, oh, no, I didn't do it, but you know what? I trust this person. They're a friend of mine. I know they're a good guy. He can be trusted. I said, well, you know what? There's nobody you can trust when it comes to business. So I went ahead and did a search for her. And what I found was what I was afraid I'd find. And what I found was that the trademark had abandoned. It had been lost 3 years earlier because the person had not filed certain documents with the US Patent and Trademark Office that they were supposed to file. So had my client gone into this contract, had they signed this agreement and paid this money, they would have been in trouble because there would not have been a trademark that was valid. That is why you need to do the search, do the due diligence at the very beginning of the process. And I also suggest that when you're collaborating with someone on a project that involves a trademark, you also want to make sure that that trademark is valid. Because again, they may think it's valid, you may want to think it's valid, but if it's canceled or if it's been abandoned or if someone has challenged it, you will have a big issue down the road. So make sure you do your due diligence. There are a couple of different types of searches. Oftentimes you'll hear people talk about a knockout search. Personally, I don't do them because I think for the most part, they're useless, except to initially determine if the mark is generic or if it's scandalous or if it's famous. If it's one of those three things that I can tell off the bat, I'm going to tell my client immediately they're not going to get it done. Because if it's generic, there's no way they'll get it registered. If it's scandalous, it won't get registered. And if it's famous, they're going to have a big fight on their hands, even if they did get it through the system. So that's what the knockout search does for me. Mostly what I do is a comprehensive search for a client because that's where I find out all the information I need to find out to determine whether there's a likelihood that this trademark is going to get through the system and actually get registered. So who is the person that performs the search? Well, sometimes clients will do it on their own if they want to save money, but if they do it on their own, that's a big job because that means they need to look at all 50 states. They need to go through the US Patent and Trademark Office federal registration, need to look at telephone books, company registries around the country, domain name searches, everything. Everything. A comprehensive search involves looking in every nook and every cranny to find out what's going on and then analyzing the search report to determine what the particular challenges might be. Search companies can also perform a search, but the problem there is they're not lawyers and they're not going to analyze the report for you. So they'll send you back a glob of paper and say, go for it. Or a lawyer can do it. I will tell you, I had a client, I've had several clients that have come to me very, very disappointed after having, for example, gone to a company like LegalZoom, and they hired them to do a search. The client didn't know. They thought, well, if I pay you all this money to do a search, you're going to tell me everything I need. Well, again, they're not lawyers. So they sent my client the last client, three big packages of papers, search reports, and the client was responsible for analyzing the search report, and they didn't have a clue what they were looking for. So the bottom line is you can go and have someone do it, or you can go to a search company and end up having to pay even more money to have a lawyer actually research it, or you can have a lawyer research in the very beginning, somebody who can analyze it, who knows what they're looking for. The next thing is to file in appropriate classes. What classes do you file in? There are so many international classes. And so when you're on the, let's see if it'll take us there. Yeah, oh, great. This takes us right to the USPTO website. Now, this link here takes you to what we call the U.S. Acceptable Identification of Goods and Services Manual. And here you can figure out what class works for you. So let's say, for example, and I'm just going to do this little tester so you can get a sense. Let's say, for example, you're doing seminars and you want to use your trademark with seminars. So you put the word seminars in here, click query. And now, of course, you have to figure out which one best suits your needs, but there's a long list. It gives you something to help you figure it out. Are you conducting seminars in the field of oncology? Are you doing educational seminars and workshops and mentoring in the field of middle school or high school? So you could look through this, but this is where you would go to figure out what seminar or what class you should use. Some of the classes that many of my clients actually use, because most of my clients are entrepreneurs and small business owners, and they do workshops, seminars, they do digital products like downloads on websites, they do DVDs, CDs, downloads, audios, all kinds of things. They might do it in class number 9, which is for digital products. They might do it for class number 16 if they're writing books or writing other printed materials. Then if they're doing it in the area of seminars, they might do class number 41. But you want to make sure you do it correctly, because if you file in the wrong class, the government's not going to pay your money back. And if you don't put sufficient amount of items in each classification when you file, then you're not going to have the protection that you really want. So again, you can do it yourself. They've got great tutorials on the USPTO.gov website. But if you don't know what you're doing, I strongly encourage you to hire someone to assist you. And today's webinar is just to give you an overview of some of the things you need to do to get that trademark and to protect it. Once you get it, you want to make sure you use it as a trademark, because a lot of times people use trademarks as nouns, and a trademark is not a noun. It's an adjective. So for example, Apple Computer, Apple iTunes, or a Google search engine. You want to use it as an adjective. If you use it as a noun, you may find yourself losing it down the road because it becomes generic. There are many companies that have fought very, very long and hard to teach, to educate the public as to how to use their trademarks. A great example is Kimberly-Clark has invested a lot of time and a lot of money in protecting the term Kleenex, because for years people would just use Kleenex when they were talking about any kind of facial tissues. So Kimberly-Clark went on this expedition teaching people how to use it. So it's Kleenex tissues, Kleenex paper towels, Kleenex napkins, but it's not just give me a Kleenex. You want to use the proper symbols. SM for service mark, TM for trademark, and R in the circle can only be used once you have a registered trademark. So SM is a trademark. It is a form of trademark, but SM you use if you have a service business, like if you're a lawyer, a CPA, a plumbing business, a landscaper, you'd use SM unless, now here's the thing, if you use SM and you only have a service business, then that's fine. But if you have a service business and you also have products, then you might want to consider using the TM. But once you have that registration, you will use the R in the circle. Number 6, you want to respond to all office actions. And if you don't know what you're doing, and even sometimes if you do, you're going to get an office action from the US Patent and Trademark Office once you file your application. Some of those office actions might be simple, they might be minor, some little procedural issue that needs to be corrected, which is fine. But in many cases, depending upon whether you were careful in the very beginning in selecting a trademark that can be protected, you might receive an office action that basically says your application is likely to be confused with an existing application or an existing registered trademark. In that case, you're going to have a fight on your hands because you need to prove to the government why they need to go ahead and allow you to register your trademark, even though this other one is existing in the marketplace. That can be challenging. So one of the ways around that is to make sure in the very beginning you choose your trademark carefully. The other thing here that's really important is the government has generally a 6-month time limit. If you miss that time limit, you are dead in the water. So not only do you have to respond to those office actions, you need to respond to them in a timely fashion. And then lastly, I added number 7 just because I thought it was really important. This is where you actually must, and I mean must, adhere to your post-registration formalities. And they include, number 1, you want to continue to use the trademark as you stated you were using it in that statement of use, which you had to file in order to actually get the registration. You want to monitor your trademark. Once you get it, it's not enough to just say, okay, I have it, and leave it alone. You want to make sure no one else is using your trademark in an unauthorized way. And if they are, you want to take some action. Now, I'm reluctant to tell you want to send a cease and desist letter because that's what people like to think, but that can get you into trouble. So if you find that someone is using your trademark, you might want to consult with an attorney as to the best way to approach it. Because if you send a cease and desist letter that is threatening, you might get a surprise. The other party might be smart and savvy enough to file a suit against you, which we call a declaratory judgment, long before you have a chance to file against them. So you want to be careful, but you definitely want to monitor that trademark. And if indeed you find someone is using it in a way they should not be using it, then you probably want to have a conversation with an attorney. 5 years after your registration, you must file an affidavit of continued use. You hear me? You must, because if you don't file between years 5 and 6, you will lose your trademark. It's that simple. I cannot begin to tell you how often I go and do a search for a client only to find out that there are all of these cancel registrations for Section 8. So that's Section 8 of the Lanham Act, which is the Trademark Act, which requires you to file an affidavit, or sometimes we call it a declaration of continued use, between years 5 and 6. The other thing, while this is not required, it's definitely something you might consider doing. At the same time, you can even, in fact, at the same time you file your affidavit of continued use, you can also file an incontestability statement. And what that does basically is at 5 years, if no one else has challenged you, you can file this statement and no one can challenge you after that, because pretty much your registration would be secure as long as you continue to renew your application every 10 years. So I see I have a little typo there. Okay, so that's a reminder that even though I try to be perfect, I see that I am not. Renew your application 10 years, every 10 years. A trademark lasts forever, not like a copyright, not like a patent, but a trademark lasts forever as long as you do these things. And after you get your registration, in fact, it'll be 5 years after you file the affidavit of continued use. Between years 9 and 10, you'll file a renewal document, which is under Section 9 of the Lanham Act, which is the Trademark Act. And then after that, it's going to be every 10 years. If you go ahead and do those things, you get to enjoy your trademark forever. ever. Okay, I think that's it. I'm Francine Ward, and let's see. I'm going to, because the chat really is not working, and let me look on the Q&A and see if any questions came in. Let's see if any questions have come in. I think, oh, you know what? I just saw that it says my screen sharing was not even showing. And so I'm not sure if you saw it or you did not. But you heard me and I talked about it, so that works. But you know what? I will actually, let's see if there are questions now, if we can do any live questions. No. Okay. So I'm going to go on to Twitter. I'll be on Twitter for about the next 30 minutes, and I will be happy to answer any of your questions. Okay. Again, I'm Francine Ward, attorney. I hope this was useful. I have another Google webinar next week. It's going to be on the 17th. And on that one, we're going to talk about how to protect your copyright, your content, your books, your articles, your web content, your blog posts, things of that nature. Okay, goodbye for now. I'll see you on Twitter. Bye-bye.